Well, I want to thank Brian Finley for coming down from Toronto and was quite helpful in explaining the importance of the opening of any brief or any memorandum. Next, we're going to turn to Brian O'Neill from Faegre and Benson Law Firm in Minneapolis, Minnesota. And I first want to mention that Mr. O'Neill, who I'll call Brian because he's been a friend for many years now in the American College, spent 1974 to 1977 as assistant to the General Counsel for the Department of the Army, and he was first in his class at the University, at the United States Army JAG School in 1974. I'm impressed with that. Brian O'Neill has had a general practice in trial and appellate areas for plaintiffs and for defendants. He's had experience in many complex, complicated pieces of litigation throughout the United States. You may be aware of him from some of his litigation in Alaska, such as the Kodiak Island Borough versus Exxon Corporation that was tried in the district court in Anchorage, Alaska in 2002. Brian has been very busy, not only as a trial lawyer, but he has been very busy in the American College of Trial Lawyers as both a fellow, as a regent for his region of the country, and on many committees, including this. He's had professional recognition in many areas, including the Chambers USA America's Leading Lawyers for Business, the top 100 super lawyers in the Minnesota law and politics. As I said, a fellow in the American College of Trial Lawyers, formerly state chair in Minnesota, as well as a regent, a fellow in the International Academy of Trial Lawyers, an advocate in the American Board of Trial Advocates, 1995 Trial Lawyer of the Year by the Trial Lawyers for Public Justice. He's listed in the Best Lawyers in America, 2008, in antitrust law, bet the company litigation, commercial litigation, environmental law, and oil and gas law. With that brief introduction on many accomplishments of Brian O'Neill, I give you Mr. Brian O'Neill.
Thank you, Your Honor. Your cases are all interesting, otherwise they wouldn't be cases. They're about right and wrong, good and bad, who did what to who, or as Tina Turner said, who's zooming who. And in order to tell these wonderful, wonderful stories about people who've hurt other people, people who've stolen things, people who have cheated other people, and in some cases accidents, you need to go back to and rely on some certain cognitive principles. There are modern-day cognitive theorists that will and can teach you an awful lot about telling stories. And that's essentially about what people believe and why. And the principles are varied. There is the principle of self-interest. People tend to do things in their own self-interest. In fact, an awful lot of people believe that people only do things in their own self-interest. And that's an important thing in telling a story. If you give somebody a lot of facts, they tend to put the facts together in a narrative. And they'll try to put as many facts together as you give them into a narrative. And that's how they build a truth. So people trust narratives. And that's a second principle. And the third principle is people resent assertions. To say somebody was a drunk right off the bat because the drunk ran a supertanker into a rock, they resist the fact that you just say somebody's a drunk. So what does this tell us? It tells us that when we write the facts for our brief, the facts have to be in a narrative format. Now, when you open and close in a civil trial or a criminal trial, you tend in the opening to do it in a narrative format, and you tend in the closing to stack the facts. In an appellate brief, and indeed in any brief, you can't stack facts. You have to tell it in a narrative format. And that's because people trust what's in a narrative format. Now, in that narrative format, we have a variety of issues. The first is where to start. Now, Lewis Carroll said you start at the beginning and you go to the end. That's not always true. And let me give you an example. I'll give you an example of the case that I've had the great fortune or misfortune of working on for 20 years. I worked on mostly on one case for 20 years, the grounding of the Exxon Valdez. Now, the grounding of the Exxon Valdez was a historic moment. And if you're going to tell the story of the Exxon Valdez, you can actually start it in three places. The captain, Joseph Hazelwood, graduated from the New York Maritime Academy in 1969, and then you can go on and tell the story of his battles with alcohol, and then go into the voyage and eventually the wreck of the Valdez. That's a starting place. Hazelwood graduating from the New York Maritime Academy in 1969. If you want to talk about corporate responsibility, you talk about the passage of the Trans-Alaska Pipeline Act in 1969 and how Exxon and the other oil companies promised that the transit of oil would be safe. That's a place to start. And if you want to be dramatic, you talk about Thursday in 1989, and you talk about the Exxon Valdez leaving the dock fully laden with toxic crude oil. At the helm was Captain Joe Hazelwood, Exxon's lowest ranked or rated sea captain, and he was drunk. So you have three places to start. And I would suggest to you that you have to think about where you're going to start. And where you're going to start depends on what's the most interesting, who or what your target is, and just flow, a sense of flow. So where to begin is a question. How to tell something rather than assert it is a question. Let's take Hazelwood's alcoholism if we could. You start, Joe Hazelwood graduates from the New York Maritime Academy in 1969 and goes to work for Exxon Oil Company as a ship's officer. And he rises through the ranks to ship captain by 1981. And there are a number of incidents that are reported inside the company with regard to Hazelwood drinking and driving a supertanker, drinking and driving an automobile. He gets in fights with crew members, has parties on board the vessel, invites women to parties on board the vessel. In 1985, he goes through a 28-day rehab program. He doesn't do his aftercare. He goes to AA. Sometimes he starts drinking again. He meets his supervisors in his back-to-duty interview at a bar. And it goes on and on and on like that. Now he's a drunk, okay? But you built the fact that he was a drunk step by step. You make your assertion after you build the case. So that fits in with the way people think about things. It fits in with their cognitive approach to things. Things have to be in the nature of things. You know, you can read a brief that somebody else has written and you can say, I really don't like the facts in this brief, and you can say, and it's a good answer, and it will be the answer of the judge that will read it. The way you tell the story isn't in the nature of things. So the story has to be in the nature of things. It has to play to an obvious self-interest of the obvious self-interest of the actors, and it can't take this position. The position, if you were at a trial, you would say, you're not going to believe this but. Okay? You're not going to believe this but means you're not going to believe it. you have to provide a motive for all of the actors. Let me give you an example. Exxon's defense in the Long Valdez trial in 1994 was, we didn't know he was a drunk, and that makes an awful lot of sense because we would never knowingly put a drunk in charge of a supertanker. Now, they took that position in the face of the top officers saying they knew he was a drunk, his shipmates saying they knew he was a drunk. But the argument has an awful lot of force because the argument is in the nature of things. And I'll tell you, 2 weeks before we started trial in Anchorage in 1994, we were struggling with that. And we were struggling with it because a position like that can cause you to lose a trial, it can cause you to lose an appeal. And the answer to the question was, they put him in charge of a supertanker knowing he was a drunk because Exxon and Exxon Shipping Company existed in an alcoholic culture. Now that's in the nature of things. We know an awful lot of institutions over the past that have sustained alcoholic cultures, including, for example, the Army in the 60s and 50s and 40s. But that rounded out the story. It made our story of Captain Hazelwood and Exxon Corporation seem in the nature of things. It made the whole narrative seem what people would expect. It didn't have any holes, and it didn't have any, you won't believe this but. Because right when you say you won't believe this but, you have a problem with anybody believing your story. Now, in a statement of facts, you have a question as to who's the bad guy and who is the good guy, and how are you going to characterize who the bad guy is and who the good guy is. In the Valdez case, Hazelwood is the guy who leaves the bridge and goes below 2 minutes before the critical turn and the boat hits the rock and hurts everybody. But Hazelwood doesn't have any money. And in addition, I'm not so sure Hazelwood was in fact the culprit. So in your factual recitation with regard to Joe Hazelwood, there's no reason to really tee off on Joe Hazelwood except for the fact that you show he was an alcoholic, unfit to be a sea captain, and you show that the real guy, Exxon Corporation, let him exist in a way that no decent human being would let another person exist. They didn't care enough about him to come up and say, Joe, you have a problem, we've got to do something about it. We'll move you to another job. So you have to pick who your target is. Everybody in the world who is on the other side from your client is not a bad guy. And it's hard for people, again, cognitively, to come to the conclusion that somebody is a bad guy, let alone 5 or 6 or 7 people are a bad guy. And the more bad guys you create, the angrier you seem. So you have to pick your bad guy. You have to pick your good guy. And the good guy or good guys can come from all over the place. For example, the medical doctors at Exxon Corporation that wanted to get Hazelwood off of the bridge of a supertanker laden with toxic crude is a good guy. So it's good to create as many good guys as you can. Now I want to talk about telling the story in words. You have to decide where you're going to start, and then you have to use real words, vibrant words. And the idea that the use of vibrant words is always overly argumentative is false. Appellate judges, federal district court judges, and I think at points in time Supreme Court judges read an awful lot of boring stuff. In fact, they read hour after hour after hour of boring stuff. And the way you make your story more exciting is using common, everyday words like drunk rather than dysthemic alcohol abuser. A dysthemic alcohol abuser is a depressed drunk. It isn't an accident when a boat hits a rock, it's a wreck. But you got to pity the poor judge who has to read your brief, and that's why you have to pick colorful, vibrant nouns and verbs. Now, I said nouns and verbs. When I edit a brief that somebody has written for me, and I don't write all my own briefs, the first thing I do, and it's kind of fun, and I do two things. One is every time he says the author says lawsuit, I cross it out and write in civil action, because the rules of procedure don't provide for lawsuits, they provide for civil actions. That's just sort of a gag. But the thing that I do seriously is I go through and I cross out every word that ends in ly. Just go through the entire factual section. You cross out every word that ends in ly. If the description with all of these adjectives and adverbs of what happened isn't vibrant enough without the ly words, too bad, he can go back, or she can go back and pick better nouns and verbs and tell a better story. I want to talk for a minute about maps, pictures, diagrams, movies, voice recordings. You can now include, just through printer technology, maps, pictures, diagrams as you go along. And it is a crime or a sin to force one of these judges to go through a narrative where location is important without providing them with a map. And you can print the map on the page. You can put the map in a pocket part in the brief. If any of you have read A Brief History of Time by Stephen Hawking, it's a physics book, and it's a very dense physics book, but the first 50 or 60 pages deal with your high school physics, and he eventually gets to a point to where he's talking about other dimensions and whether they're 9 dimensions or 11 dimensions, and you just stop. And I've always wanted to complete the book, and I read it, I have it in my briefcase, and I read it whenever I get on an airplane, and I always get stopped about page 56, either because of the wine I'm drinking or because I just don't have the wherewithal to get through page 56. But Hawking, about 3 or 4 years ago, issued A Brief History of Time with illustrations. And now I've gotten all the way to page 78 or 79. So illustrations help. When we were in the Supreme Court this last year in the Valdez case, we had an amicus brief from a group that represented natives. And the author of the brief had a narrative going, but every 2 or 3 pages he would have a full page in the brief of a Native American scooping oil up from a beach or down on their hands and knees with actual teaspoons or sponges cleaning oil up. And I thought that that was an awfully good use of the space. The pictures were from a National Geographic article that ran in 1995, but it was compelling. The pictures in the brief were compelling. Why don't we do more pictures in briefs? Patent drawings. It's awfully hard to talk about an invention without having the patent specification or a patent drawing or a schematic of the patent in the factual section. Now, today, the world is a better place than it was 10 or 15 years ago because of computers. In the Ninth Circuit briefing that we did in the Valdez case, we put it on a CD so that you could go through the brief, and every time you wanted to look at page 76 of the transcript, you clicked and you went to page 76 of the transcript. If you wanted to hear Captain Hazelwood telephoning in a drunken voice where he was south of Bly Reef, you could click and it would play him phoning in south of Bly Reef in a drunken voice saying he'd run aground. If you wanted to see the Valdez, you could click. If you wanted to go to a jump site in a case, you could click. And the vendor we used on a page of transcript would actually highlight the paragraphs in yellow so that the clerk or the judge, if he wanted to click and check the site, could click and check the sites. The whole brief was interactive with the record. Wonderful. The Supreme Court doesn't provide for that. We did lodge a CD, though, with the Supreme Court with what we thought were the best exhibits, the best videotapes, the best animations, Hazelwood calling in, and lodged the CD with the court, and we figured that the clerks would be interested in what was on the CD, and it would become a commodity. They'd steal it as a souvenir, but by gosh, they'd look at it. So in telling your story, you can do a lot more with things than we used to be able to do. Now, when you write your brief, in the fact section of your brief, you have a question with regard to actually what story you're going to tell. There are constraints on you with regard to the story that you're going to tell. The primary constraint is, what's the posture of the case? Is it an appeal from a summary judgment in which you have to recite the facts as they would be adverse to the moving party? Is it an appeal from a set of findings and conclusions in a judge case in which you have to talk about each of the findings and conclusions? Your posture, the posture of the case presents a constraint, and you have to give that cognizance because the judge will read the brief and expect you to talk about the facts depending upon the procedural posture. Then you get to adverse facts. And are you going to put in adverse facts? Do you have a duty to put in adverse facts? Is it a good idea to put in adverse facts? They expect you to put in adverse facts. And if you don't put them into your recitation of what the facts are, the bad guys are going to put them into their recitation of what the facts are. So you might as well put them in, place them in context, and if you want to talk about why this adverse fact or this adverse fact that the other people are going to bring up are out of sorts, you can do it in a footnote right there. Now I want to talk for a minute about some problems that you're going to have with the facts section of your brief. And the biggest problem that you're going to have is you've been drinking your own Kool-Aid. And that is everything from overzealousness to short-sightedness to the fact that you have favorite facts. You know, if you live with a case for 2 or 3, or in my case, 20 years, you always remember that wonderful question in that deposition that you thought just brought the house down that was going to win the case, and it creeps into all of the briefs that you ever write on the case. You got to get rid of your favorite facts. And it's interesting if you draft a brief with 3 or 4 friends who've worked on the same case, and you find out that there are 3 or 4 different favorite facts, it comes clear you get rid of the favorite facts. You can't believe you can't drink your own Kool-Aid. You can't believe your own version of things, which leads me to a bigger problem, and that is clients always drink their own Kool-Aid. And you have a brief, and the more in control your client is of the litigation process, the more your client is not going to let you come forward to the court with an honest and effective presentation of the facts. In fact, sometimes they won't allow you to do it at all. You lose a jury trial, and the general counsel of the company or your individual client says, I don't care what they proved. I don't care what the inferences are with regard to jury trials. We're going to put my version of the facts in here at the Court of Appeals. We're going to put them in at the Supreme Court until hell freezes over. That's an issue that you have to deal with. You have to deal with that issue by conditioning your client ahead of time, and you got to be willing to have the client get a little bit angry with you if you're going to do an effective job for the client. I want to talk now, and my last one is never do witness by witness. You're going to say, well, what do I do in the case of where there are actual credibility issues in the district court below? And you're telling me never to do witness by witness. You never do witness by witness in the facts section. If it's not important, you can make an assertion in the text and drop a footnote and do X said X, Y said Y, and Z said Z. But it doesn't interrupt the flow of things, and you drop it in the footnote. If it's important, if there's an actual credibility issue with regard to what witnesses said what to who, do it back in the argument section. And argue it the way you should back in the argument section. Now, read your text aloud when you finish it. Your factual text aloud to make sure that it sounds like a novel. And as you read it aloud, you'll find out that you're using an awful lot of legal words that you ought to get rid of. You're not using the best words that you can use, but read it aloud. And again, cross out all the LY words. I want to talk for a minute about your audience. Your audience is a strange group of people who have to read all of the time. And they teach themselves to read quickly, and you have to help them through the reading process, and here are some tools that you can use. The first is headings. Every 2 or 3 or 4 paragraphs stick in a heading. It doesn't even need to be numbered. The Fateful Voyage, Hazelwood from 85 to 87, The Grounding, Rocking the Vessel Off the Rock. And you stick in these headings whenever you change the topic, and the headings ought to have some meaning to them. They ought to be part of the story. But they help the busy reader. Topic sentences and short paragraphs. You have to make sure that there's a topic sentence for every one of the paragraphs. And with regard to short paragraphs, even if you have to break up what you would normally think is a good paragraph, to keep them into short paragraphs, do so. You got to break them up. Abbreviations and acronyms. Don't. Just don't. Appellant and appellee. Don't do that either. I mean, if you read 8 or 10 briefs a day, and they're all talking about appellant and appellee, or plaintiff and defendant, your mind's going to go mush. It's Exxon Corporation and the fisherman, or Captain Hazelwood, or whoever it is. But they have names, use their names. Now, I'm going to get into something that's controversial in the legal profession right now, and that is the placement of citations. Brian Garner, who many of you have heard, is probably the leading person in the United States today on how to write a brief. He's the editor of Blacks and the editor, I think, of Modern American Usage. And he wrote the book with Scalia. Well, I think Brian Garner wrote the book, and now I got a letter from Justice Scalia about this. At least in the facts section, put the citations in the footnotes so that it reads like a novel. Because your eye's going across, and the guy's getting some momentum up, and you've used colorful words, and the story's going, and he hits citation and he stops, and he hits citation and he stops. Drop all of the citations in the facts section, whether they're to the transcript or another part of the record, into footnotes. And then you got a neat read. I could argue this subject differently when you get to the discussion of the law later on and whether the cases ought to be in the text or the footnotes or both. But at least in the facts section, let's put them all in the footnotes and make it read well. Garner teaches a lot out in the Ninth Circuit. And if you read the opinion of somebody like Andy Kleinfeld or Kaczynski or somebody like that, you'll see that they put an awful lot of their stuff in the footnotes, and it's a lot more entertaining read. So I commend that to you. Don't clutter the text with dates. Because every time you put a date there, the mind says, I got to remember the date. The only dates that you want are those absolutely necessary to control the chronology and those that are necessary to an issue. You have tomorrow, soon after, later, a half a year later, but don't clutter the text with dates because you're using up his storage. Don't insult judges and lawyers. In fact, there's no need to insult almost anybody. When I was a young lawyer, I tried an antitrust case. And in antitrust cases, the problem is always salesmen. In fact, if you're going to be a professional lawyer, you ought to really understand salesmen. There are 3 great movies, The Tin Men, Gary Glenn Ross, and Cadillac Man. And some weekend you ought to get all 3 of them and watch them, but they're a real exploration of what the soul of a salesman is like. But this salesman was key to our defense in the case. He comes into the office, we prepare him. I say, don't bring anything in your pockets to trial, because salesmen will always bring a little notebook of everything you told them in their pocket, and then the other lawyer will ask for it, they get it. So he goes onto the stand and he's cross-examined by the other lawyer, and the other lawyer says, did you bring anything here to the trial that has to do with the case? And he says, sure I did. What is it? Well, it's my notes from meeting with Mr. O'Neill yesterday. Now, this is just as predictable as a drunken skipper running a boat aground. So the other lawyer says, could I have the note? And he gives him the note, and the other lawyer says, I can't read your handwriting. And there's only one sentence on it. What does it say? And so the salesman takes the note and he reads it. Nobody likes an asshole. That's, in fact, what I told him. But you take that sentence onto a broader context, and it's right up there with what comes around goes around, or things have to be in the nature of things to be true. But in your writing, there's no need to tee off on anybody other than the bad guy. And when you tee off on the bad guy, you do it in a way that it is not an assertion. You build it, establish it, draw your conclusion. Now, I do want to talk for a minute about what I might refer to as technical writing. And that is, the system itself has some constraints that it places on what you're going to write for your facts. The first is, always make a complete counterstatement. It's easy to say I agree with Joe's facts. With these 2 or 3 exceptions, don't do it. Make your own counterstatement. Accuracy and citations, which are in your footnotes, because we've already discussed that. Assume that they're going to check all of the citations and be as accurate as you would expect anybody else to be. There's no need to fudge, and I read an awful lot of briefs where people do it all of the time, and all you need to do is miss on one and nobody believes you after that. Limit your fact section to what's in the record. In your facts section, don't make arguments, because the judges say we have a fact section and an argument section for a reason, and it irritates them. So don't make arguments in the fact section. Electronic briefs and CDs, I'm for those. I think we're going to see more and more of them. You can file them in most of the federal courts of appeals today. When you do it again, highlight on the page so that the reader, when he clicks to the record, can see right where it is. And intersperse video, audio tape, animations. You can do a lot of neat stuff. Now, I want to finish up by saying that this has been fun. If you want to be a better writer, I would echo what Brian said, and that is, you got to read a lot. Judge Easterbrook gives a speech to appellate writers just on the subject of what good book lists are, but I also agree with him. You ought to read Hemingway. Hemingway doesn't use a lot of adjectives and adverbs. Hemingway writes in the active as opposed to the passive voice. Hemingway uses colorful words. Hemingway would have been a great, great appellate lawyer. Strunk and White, The Elements of Style. I go back and I reread it once every 2 or 3 years on the same weekend where I'm bored, and I reread the rules of evidence. But it's a good thing to do. It's a wonderful Wonderful book. It had, omit needless words. One of the great, great sentences of all time, omit needless words. It's like Weird Al does a takeoff of one of the Beatles songs. The song only has 6 words. Same deal, omit needless words. But I would go back and reread Strunk and White every year or two because it's a good thing to do. I give Strunk and White to my young lawyers. I expect them to read it. And now I want to go back to where I started, and it's the most important thing with regard to the facts, and that is they ought to be chronological. You ought to make a solid decision on where in the story you're going to start and stick with your chronology. The story has to reflect both the record accurately and it has to reflect the nature of things. And if you think it's weak enough to have to say you won't believe this but, you've got a real problem and you better go back and rethink through how you're going to tell your story. So that's what I had to say. I think I omitted all of the needless words and I'm going to sit down. Thank you.
Well, thank you, Brian O'Neill. It was an excellent description of writing factual sections of your brief. We're now going to turn to Bruce Rogow, who's a professor of law at Nova Southeastern University Law Center in Fort Lauderdale, Florida since 1974. In 1978-79, he was a co-dean of the Law Center. In 1984, the acting dean. In addition to teaching, Mr. Rogow has litigated extensively over the past 44 years. He has argued hundreds of civil and criminal cases in federal and state appellate courts, including 11 cases in the United States Supreme Court. I'm just going to give a short description of some of his background. He's also been appointed by the Supreme Court in cases to present to the Supreme Court. In the 2000 presidential election litigation, he was counsel in the Supreme Court for the Palm Beach County Canvassing Board in Bush versus Palm Beach County Canvassing Board. He has been listed in every edition of the Best Lawyers in America, which goes on for 20 years. He's listed in 4 categories: appellate law, commercial litigation, white-collar criminal defense, and First Amendment law. He is listed in Chambers USA, America's Leading Lawyers for Business. He is one of 3 lawyers in Florida to have been board certified in both civil and criminal appellate law and was elected to the American Academy of Appellate Lawyers. He is a fellow in the American College of Trial Lawyers. He's won numerous awards, including the Reginald Heber Smith Award from the National Legal Aid and Defender Association and the James C. Adkins Award given to Florida's outstanding appellate jurists or practitioners. In fact, he was the first practicing lawyer to receive the award. In December 2007, he was named the most effective appellate lawyer in Southern Florida. Mr. Rogow has represented governmental entities, public officials, trial and appellate judges, law firms, lawyers including F. Lee Bailey, and corporations in major trial and appellate advocacy. He has served as a consultant to lawyers and legal aid organizations and as an expert witness in many cases. He has lectured to judges and lawyers, writes and has been president of the Legal Aid Society of Broward County, Florida, and special counsel for the American Civil Liberties Union Foundation of Florida, special counsel to the Florida Bar, and a special assistant attorney general. So please give a warm welcome, Mr. Rogow.
You know, most importantly, I've had fun for 45 years being a lawyer. That to me is really the highest calling, the pleasure that you get out of being a lawyer. Being near the end is helpful because there are a couple of comments one can make after having listened to the other speakers. A couple of things came to mind. When Sylvia was talking about the left brain and the outline, here's how I handle that. I outline in Hebrew because it's from right to left, so that's taken care of. I agree with both Brians. You have to read in order to write briefs. And I think reading books, reading The New Yorker, for example, to me is one of my favorites. But don't read Faulkner. Faulkner will not help you at all in that. I disagree with Brian about putting the record citations in footnotes. I think that that's distracting, and I know this is an issue, and I know that Garner seems to be promoting that idea, but I don't like that idea at all. I think for the most part, judges, and this goes to some extent to what I'm going to be talking about, judges are law-conditioned officials, and they're used to reading briefs with the record citation right in there, transcript 222. They'll just glide right over it. But to have a footnote, and in fact, if you're writing a statement of facts that goes on for any length, you'll end up with 30, 40, 50 footnotes. I think that's pretty distracting. So we have a disagreement about that. But I do agree with so many of the things that everyone has said. But one of the things that Brian talked about, too, in terms of the hyperlink briefs and the CDs reminded me of this. When I represented Two Live Crew in the obscenity trials, one of the things, of course, that you have to put into evidence to show community standards is what was available in the community and how the record, as nasty as they want to be, was not really as nasty as what was available in Broward County. And among the things that I put in, and this was great fun in federal court, was a video that I bought at the local porn store. You know, you had to do your research, and so it was hard work, but somebody had to do it. And it was a spectacular video. I mean, I checked out several in order to make sure I had something that would really be moving. And so I introduced this video, and there were 3 segments to it. And after the first segment, I knew that the judge, didn't want to have to see the other 2, and the state stipulated that the other 2 segments of the video were similar, and so I just put it in. We didn't have to play the whole thing. When the record went up to the Court of Appeals, all of the material that I'd introduced was part of the record in the Court of Appeals. In fact, some of it, by the way, now the Rock and Roll Hall of Fame has in Cleveland, although they keep the harder core stuff separate. But anyway, this video was there, and after I won the case in the Court of Appeals, and the record came back down to the district court, they called me and said, "Mr. Rogow, go pick up the record on appeal and all of the exhibits because we don't need them anymore." So I did, eager to get that video back. Somebody in the clerk's office had stolen the video. So somebody did take it as a souvenir, and you reminded me of that. It's interesting when we talk about arguing the law. Some of the things that have been said today, I think, are tied in, of course, to the legal argument. I mean, you can't argue the law without dealing with the facts. And in terms of outlining, as Sylvia has talked about, you have to be thinking about the case before you put your pen to paper to begin to write your brief and do your outline. But I'll tell you what I think about when I'm beginning to think about the law. I think about what I'm going to say when I get up to do my opening in the argument. The effective opening in the argument, to me, is something that helps me shape how I'm going to argue in the brief. The most effective opening argument I ever heard was in a denaturalization case where a Nazi had gained U.S. citizenship by lying on his application for U.S. citizenship. And the argument in the Supreme Court began this way. The issue in this case is whether or not a good Nazi can be a good American. Case was over. It was a brilliant opening. I've always tried to find a way to use that in my arguments, but you just can't plug it into many cases. But what it taught me was think about what you're going to be saying in the court when you're standing up, because that is going to have provide some insight to you in how you want to shape your brief. You've heard the word theme, and theme is important here. You have to have a theme in your brief, a theme with regard to the law, a theme with regard to the facts. The facts, as Brian was talking about the Exxon Valdez situation. You've got a theme, that is going to be part of your case. And if you think about that theme at the very end of your case, at the oral argument, it will help provide you some insight into how you want to begin to outline your brief and shape your brief. So I think that is something to think about. The effective opening at the argument can be helpful in terms of providing an effective opening for your legal argument in your brief. These are law-conditioned officials that you're arguing to, and we've talked about the judges and the burdens that they have in looking at your briefs. What you have to realize is that they've all shared the same experience that you and I have shared. They've gone to law school. Now, different law schools have different approaches, and different law schools may emphasize different things, but we're speaking the same language, and that's very helpful in terms of knowing your audience, the law-conditioned officials. In the materials that I provided, I recommend reading Carl Llewellyn's book, The Common Law Tradition. I think that's such an important book. He is one of the great legal philosophers at the University of Chicago, long since deceased. But Carl Llewellyn will provide you with some insights into what the appellate process is all about. And the notion that you're speaking to law-conditioned officials, I think, is helpful in terms of how you shape your approach to them. And there are leeways when you're talking about arguing the law. I mean, the leeways that the law provides to these judges to be able to maneuver within the law. You know, the law is not a science, and this, in many ways, is really the most important theme of my case. The law is not a science. There isn't a single right answer, and I want to come back to that in a moment. But in terms of the leeways that an appellate court has in responding to your legal arguments, you have to understand what those leeways are. One of them, of course, deals with standards of review. So if you're arguing the law, the standard of review is critical to you. If it's a de novo standard of review, the court obviously has much more leeway to deal with the decision below. If it is an abuse of discretion standard of review, then you're going to have a much more difficult time. So understanding at the outset the standard of review helps you shape the way you want to approach your legal argument. And you know, I think that a good appellate lawyer will almost always be able to predict the outcome of the case. Predictability is an important factor here. And you've heard the other speakers talk about honesty. Don't drink your own Kool-Aid. Don't be blind to the arguments on the other side. All of these are very important concepts to keep in mind, but they bring me back to this kernel, which has always been for me the most important aspect in the honestly arguable case. And that's what we're talking about. We're talking about the honestly arguable case. You know, some cases are open and shut, per curiam affirmed, nothing more to be said about that. And that goes to predictability, too. You'll know that is the likely outcome of the case. But in the honestly arguable case, there obviously is room here, and so persuasion becomes very important, and understanding that there's not a single right answer, and sharing that with the court, I think is essential to being effective in terms of arguing the law. And now I'm only talking about the law. When you think about the decisions in the Supreme Court that are 5-4 and the decisions in state appellate courts that are 4-3, I mean, that underscores for you that there are two sides. One philosopher once said that the only honest place to be is between. Between is the only honest place to be. And I think that is an important concept when you begin to think about arguing the law, because one, it forces you to recognize the merits of the other side's argument. It forces you to be objective about assessing the case law that you're going to be arguing. And so if you avoid the single right answer syndrome, then you've gone a long way to beginning to find a way to shape the argument that you want. And so if I am right that in the honestly arguable cases there isn't a single right answer, then the question becomes, what are you looking for? What are you searching for? And what are you trying to lead? Because that's what you have to do. You're not going to pound this into some appellate judges or appellate panels consciousness. What do you have to lead them to? You have to lead them to the better answer. Sometimes it's the best answer, but I don't even like to go that far. You know, when Tim was talking before, and I know he exaggerates because, you know, it is a good way to communicate, I guess. But when he was talking about beat him to death, do all that, boy, I mean, that completely is foreign to me. The lawyers I have dealt with over 45 years, and I started in Mississippi in 1964, so I had people who probably wanted to beat me to death. But nobody that I've litigated with has been in that kind of frame of mind. They've been great lawyers, and they have looked at it the way I'm suggesting you to look at it, that there's a better answer. And so they are effective because they are trying to lead the court to the better answer. And if you say to a court and recognize and acknowledge that there's not a single right answer, that there is merit to the other side's position, it'll do a couple of things. One, it will cure you of the ad hominem kind of attacks, which everyone has warned you against already, but it gives you a frame of reference for avoiding that. It teaches you respect, because that's really what you're doing. You're respecting the fact that there is more than one answer to this honestly arguable question, and that then begins to shape your argument into leading the court to the better answer to the question. Now, because the law is not a science, because you can obviously find support for differing positions in the honestly arguable case, the question then becomes, how do you present it to the court in a way that will be persuasive to them? Well, first of all, you do have to find your best case. I'm not a big believer in long string cites of a lot of cases. I mean, there are a couple of cases that will do the job for you, and that's what you need to get to, those couple of cases. And if they do the job for you, then you have to state them boldly. Here are the cases that support our position, and do it early in the brief. You know, this becomes an issue too. In the summary of argument, a lot of people I see avoid citing a case in the summary of argument. But if you have a case that is big and bold for you, then I would put it in the summary of the argument. There's always a debate about whether or not judges read the summary of the argument or not. My experience talking to judges is they do, because for all the reasons you've heard about how much they have to read, why not read a page or a page and a half summary that gives you this quick insight into the case? And if there is a case, a precedent that is important, then put it right there in the summary of the argument. It shapes everything else, because the court then goes on to read the rest of the brief, knowing that you have alerted the court to this case that you think is so helpful. So in arguing the law, take your best case or cases, but not too many. Because if you get too many, then you're just stretching the point, and you don't need to do that. And argue it boldly, and address the other cases, why there is another viewpoint, but why that viewpoint doesn't lead the court to the better answer in the case. And one of the things that I think that's important is this, is what will move a court, where you've got the cases that seem to give each group of judges a way to go, but it could be a different way. Well, I think what you have to come to, and it was mentioned before, is the responsibility for justice. And this is one of the things that Llewellyn talks about too, the responsibility for justice. The ultimate, I absolutely agree that appellate judges are seeking to do justice. Now, the trouble, of course, is that one group's sense of what justice is different from another. I quoted in my materials, and it's too long a block quote, but I wanted to make the point. I quoted the Kerrigan case out of the Connecticut Supreme Court about 10 days ago, in which under the Connecticut Constitution they found that marriage between members of the same sex could not be prohibited in Connecticut, and it's a 4-3 decision. So what do you get from that? 4 justices of the Connecticut Supreme Court felt a responsibility for justice, thinking about the Equal Protection Clause of the Connecticut Constitution. But 3 justices of the Florida Supreme Court found that the Connecticut Constitution didn't provide that kind of protection. And so that's a great example of a situation in which it's an honestly arguable case, 2 different opinions. The responsibility for justice is seen differently by the majority than by the minority. So how do you put this responsibility for justice notion into play so that you can get that 1 extra vote? Well, knowing your court, obviously, is critical to this. Understanding who you are applying to and who you are trying to persuade. But of course, courts change. Times change. You know, it's very interesting today watching the nationalization, basically, of American banks and private enterprise. In the mid-30s, when President Roosevelt sought to accomplish some things that would have assisted in the recovery from the Depression, the Supreme Court struck down those things. Those were violations of the Constitution in the Supreme Court's mind. And then when Roosevelt talked to the public about trying to have extra justices so that the court packing scheme. Within a month, Justice Roberts, Owen Roberts at that time, who was a Chief Justice, changed his mind and upheld one of the congressional acts that would have 6 weeks or 10 weeks before perhaps been struck down by the court. And what brought about that change? The sense of the public. Today, of course, I don't think anybody's going to challenge as illegal the federal government having interests in the banking and the financial life of the country. So times change, and that's one of the things that Llewellyn talks about too. The general period, style, and promise of the future. And so that's something that you need to think about in terms of talking to the court about why you're providing the better answer and bringing into play what is happening in the country, being knowledgeable about it and bringing it into play in a way that the court will relate to, not be turned off by, but relate to because judges read. You know, I saw something extraordinary this morning in the paper. I think it was Missouri? What court struck down? There's a Halloween law that is it Missouri? The district court struck down the statute that people who've been convicted of sexual predator crimes have to stay in between 5 and 10:30 on Halloween. I mean, it's bizarre, I thought. And yet, some parts of the law, I think, were upheld in that decision. But that is an example of general period, style, and promise. I mean, and especially the general period style on Halloween Eve. I mean, this is the general period we're in. We're in the Halloween time, so we get these scary kind of cases that deal with these kinds of issues. But again, you have to recognize that you're part of a larger picture. And don't be so narrow-minded that you only think about, here's what this case says, here's what that case says. If you're going to argue the law in this country is the product of the group experiences that we all have. So stay away from the single right answer syndrome. Understand that times change. Understand that that being between can be the only honest place to be in the honestly arguable case. Now, you have a little different problem when you're dealing with a 3-judge panel. You know, in the intermediate appellate courts in most states, you have a 3-judge panel. In the highest state courts and in the U.S. Supreme Court, you have the full en banc court. So their opinions are written. When you write the brief, you know in those courts where you're writing for a full court, you know where everybody has stood in the past. I mean, changes happen, obviously, judges get replaced, but generally you have a sense. But when you're writing for a 3-judge panel, you don't know which 3 judges you're going to get. And can it make a difference in the outcome? Absolutely, it can. And so what do? You can't write for the, quote, liberal, if you think about it that way, for the liberal judges who might be on a 13-person court. You have to write for the whole court. And I think that's a very helpful thing to keep in mind, because you are simply trying to put something out there that will be acceptable to all of the judges, not just a coterie of judges that you might hope might be on your panel. And I think that, too, is something that plays into avoiding the single right answer syndrome, because different judges will have different reactions to what it is that's being asked of them. So I recommend that you read the Llewellyn book, The Common Law Tradition. I've recommended also Frederick Bernays Wiener's book, Briefing and Arguing Federal Appeals, 1967. You can probably buy an old copy on Amazon, although I don't think they're so cheap anymore. I think it's the best of all of these books on briefing and arguing appeals. Now, Wiener is an old school person. He was a deputy solicitor general. I saw him argue Moose Lodge versus Irvis, too. But he, I think, has a very good sense back then of what it took, and I think that sense holds true today. I am amused by the Scalia book. I think it is so trite in many ways, so superficial, but it's so amusing, just like Justice Scalia. So it's worth reading, and it does give you general principles. You know, nobody is going to disagree about most of the things that we've talked about. State the facts honestly. When you cite a case, make sure the case stands for the proposition that you're citing it for. Don't use a full page of block quote. I do like the voice of the court a bit. I don't like a long block quote, but I do think a short quote, maybe 4 or 5 lines if it's a block quote from the court, is helpful, because then when the appellate court is reading your brief and you say, this is what such and such a court said, it's going to have to go and read the case to see if you really have stated it correctly. But if you have the voice of the court, then I think the voice of the court can be very helpful. Don't overdo it, but I think a little bit of that. And tying it into the facts a little bit too, I don't know if Brian agrees, but I even like the voice of the witness. Sometimes it's better to have a nice little quote about what the testimony is than for you to recharacterize the testimony. But what's the bottom line here? The bottom line here is knowing the court to which you are arguing. And I'll leave you with this story about knowing the court. When I was in Mississippi, this was, I think, in 1965, a young fellow was arrested in Sunflower County, Mississippi, which was the home county of Senator Eastland, who was the chairman of the Judiciary Committee, an old-time racist, and a very difficult county, Sunflower County. And he'd gone into the courthouse wearing a T-shirt that he'd gotten after a James Bond movie, and the T-shirt said "Pussy Galore." Remember the James Bond movie where Pussy Galore was the female character? And they arrested him for wearing an obscene T-shirt. And I got an original order from the Mississippi Supreme Court. I filed a habeas corpus petition in the Mississippi Supreme Court. This was before Galt. He'd not had the advice of counsel. No one told him that counsel could be appointed for him. And he'd been convicted and sent to the state school. He was 16. He would have had to do 2 more years in the state school without counsel. So the Mississippi Supreme Court granted his release pending a full decision on the habeas corpus petition and ordered him to be released in my custody. So I go down to southwest Mississippi, and of course it was a segregated state juvenile facility. And I go in and I have this order, and I get a hold of the warden, and I say, Mr. Warden, I'm Bruce Rogow, and I've got an order here from the Supreme Court releasing young Mr. So-and-so in my custody. He said, can't have him. I said, Mr. Warden, the Supreme Court has said that you've got to release him in my custody. He said, I ain't giving him to you. I said, Mr. Warden, the Mississippi Supreme Court. He said, oh, the Mississippi Supreme Court. That was the difference. Thank you.
Thank you, Bruce Rogow. It was an excellent presentation. We'll turn to our last speaker of the day, Michael Colby, who some of you may know is a professor here at Washington University College of Law. He is the director of Trial and Advocacy Program, the associate director of the Legal Practice Program, the senior lecturer in law, and at the school he teaches many courses, but included among those are advanced legal writing. I guess he's also, from about 94 to 2001, was the director of Lawyering Skills Program at the Columbus School of Law at Catholic University of America. He has also been a faculty of the International Law Institute in Washington, D.C. from the summers of 1975 to the present. With that, Professor Colby.
I think you said 1975, was that right? I haven't been teaching there since 1975. I think it was 1995, but maybe I misheard that, but I may look not quite that old yet, but getting there. So I only have about a good hour and a half of material for you today. So we'll just try to get through this as quickly as we can. No, of course not. In fact, I've been given kind of the trite, the idea of editing, right? But I think it's also very important. And as I thought about what we should do here today, I thought about, all of the different pieces of advice you get, the tips you get as far as what makes good legal writing. And I know you've heard them a lot, but I thought, we're just going to give you four things that you should look for in your writing. I have to say that if I were to say one thing to all lawyers in their writing, and I could only say one thing about writing, if you limit it to me just one thing, it's just one sentence, one thing you should do, and it's from this packet here, is that your sentences are too long and your paragraphs are too long. And I think when you think about editing your material, you'll edit for a variety of different things, for structure, and then you get down to the fine tuning of the document. And I have to say that lawyers tend to write, just like you read all through law school, these long, hard to follow, convoluted sentences. So if you look at these two first example here in the packet there, you have this sentence which may kind of almost seem funny, but it says, in the first month of his marriage, the defendant, who was only 18 at the time and who had not completed high school, had developed a trade, and who had just lost his part-time job, was charged with robbing a convenience store at the corner of Forsyth and Jackson Avenue. Well, that's a long sentence. And so you break it up. But what I suggest you do is, if you look at your documents, you go through and you look at sentence length. And you see anything more than 2 lines, I would look at it suspiciously. Not to say you have to have all short 1-line, 2-line sentences, longer ones to mix into varying your sentence length. But I guarantee you, if every lawyer limited the sentence length and said they're not going to write any more long, convoluted sentences, the world would be a much better place. And I would say that paragraphs too. Paragraphs, if you look at your paper, you should be able to see nice blocks of paragraphs. Now that is pretty simple, something you already know, but something I think to systematically go through and look at. The second way to, or concrete way to deal with editing your own material. This is pretty tedious, but I started to do this with some things that I had written. And it really worked. When Mr. O'Neill was talking about omitting unnecessary words, well, what does that mean, really? And one of the things that I think is a good technique is to go through, you really can go through sentence to sentence, and I guarantee you take any brief out there, anything in these packets that we've looked through here, and we could make it better by doing this one exercise, is to go through and underline the meaningful words of every sentence. What words matter to the content? So, if you look at this first example, a trial by jury was requested by the defendant. Well, if you looked at the meaningful words, you have defendant, requested, jury trial. The other words are not meaningful words. And so obviously this is passive voice, and really no editing talk could be complete without a reference to the passive voice. But the defendant requested a jury trial. You kind of have those, the connecting words went down from 5 to 2. Look at this next example. The ruling by the trial judge was prejudicial error for the reason that it cut off cross-examination with respect to issues that were vital. Again, if you were to look at the revised version, you get rid of a lot of these extra words. You go down from 14 to 5 of those extra words, right? Things like with respect to, for the reason that. If you go just for the meaningful words in the sentence and redraft it, I think you'll tighten up your writing. And there are a couple more examples. That next one, the testimony that was given by Glickman, went to the heart of the defense from 17 to 5. But these are the type of, I think, editing, going line by line. Obviously you're thinking, I don't really have time for this. And obviously, to do this line by line in every document you ever write would be fairly tedious. But what I found after doing this is that I don't use with respect to anymore. Or, you know what my favorite one is? I see it all the time. In order to determine causation, you can usually get rid of that. It's not a meaningful word. And so what happens is that I've done it, I did it 5, 6 times, and then all of a sudden when I start writing, I just don't, I have it in my mind. These phrases just don't enter as much into my writing. And the more you do it, I think you'll find that you'll get rid of, in the event that, for the reason that, with respect to, all of these unnecessary words. The second part of this, there's really 3 parts of this, is all of these preambles. If you notice at the very bottom of the page, if you went through your writing and you were edit your writing and say, I'm going to get rid of, first of all, the first one is my favorite. It is interesting to know. I mean, don't fool anybody. Nothing you're writing is that interesting. And so it's a lie, but it's also unnecessary, not very efficient way to present things. It's important to remember that it seems that it's clear that is, with respect to all of those phrases. The last technique here would be on the second page of that handout, is that you can do a search function on your, obviously on your, with your word processing. And what I'll do is I'll do, find, and then I'll put it is, or there are, or I have a few things that I'll look for, and to kind of edit out the it is and there are. But that, I think this one, if you were to say, I think the first, if you're a lawyer to write shorter, more simple, direct sentences and not all these clauses thrown in the middle, the world would be a better place. And I think lawyers are known for all of these unnecessary words. We heard that from Mr. O'Neill, and this is one way to kind of get rid of that. The third I just put in there because, again, no editing talk is ever complete without a reference to the passive voice. We heard it from almost three of the speakers, and I remember growing up and hearing about the passive voice. My son, who's 13, my 10-year-old even hears about the passive voice at some level, and I don't think I ever knew what it was. And you would think that we could stop saying this about the passive voice, but it is everywhere. It's something that creeps in your writing as the default way of writing, and for some reason, lawyers think it sounds more lawyerly to use it. And it's one of those things that creeps in your writing, especially in academic writing. It's the worst. And it's something, again, you have to go line by line and always look for it. I know some of the word processing will look for it as well. But I thought I had to use it now. It was a little of an attempt at a joke there. The passive voice should be avoided is passive voice. Kind of late in the day for a lame joke, I know. But there are just 2 examples there. And the problem with the passive voice is we don't know who's doing the acting, and it makes for very unclear writing there. Now, I have to say the passive voice is good. It always has a bad name, right? But there's a good use for it as well. So if you think about it, we don't really care who published the books. They were published in 2005. So that's not bad. It's when it becomes the default. And, if you looked at any filing, you'll see a complaint was filed, an answer was filed. That is passive. Now, is it clear? I mean, usually plaintiffs file complaints, but it is passive. It just sneaks into all writing. It's when, the second example is a good example of when it's bad. It was insisted that the contract had been breached. Well, who insisted? Who breached? And to be very clear, making the actor. But we like the passive voice for avoiding responsibility, right? Presidents say mistakes were made, never saying I made the mistake as the President of the United States. Mistakes were made. But, if your client strikes a victim 4 times, you probably want the passive voice, right? The victim was struck 4 times. You know, not my client struck this person 4 times until he bled to death. No, we don't usually use the active voice there. I kind of put that in there because, I mean, I think, you know, again, the passive voice is such a mainstay of editing. It would be just a sin not to include it. But the fourth technique, and this is it, is dealing with transition. So once you kind of go through and tighten up your writing by focusing on meaningful words, making your sentences and your paragraphs more manageable components for your reader, when you have no passive voice except for when you want it. One of the editing, you know, if I were to say when I read legal writing, I find that people have a hard time maneuvering through their writing and with transitions, right? And really leading the reader along in a way that's fluid. Now, I'll tell you what helps you, and I think we heard this as well from Mr. O'Neill, dealing with headings, right? Headings in a fact section moves the reader along. Those are a good way of transitioning readers. So in legal writing, we have actually a much easier way to transition than in other forms of writing. But with, you know, for example, in subheadings with argument, in a brief, for example, helps you move your argument along. What I find, though, is when I look at the longer arguments, or even a sub-argument without a heading, I find that the best legal writing has really good transitions. And there are really 3 different ways. I mean, I already talked about dealing with headings as one way. Another way is getting a real good sense of these generic transitions. I've kind of compiled this over time. And I never write anything without this kind of close by, because if you're like me, you have your 1 or 2 words you like, you know, if you're a however person. But I'm thinking, you know, if you think back and you're editing your work and you say, what am I doing here? What kind of, you know, what am I doing with this paragraph to this paragraph, or this idea to this idea? Sometimes we can use generic transitions to move our argument along, our document along. And, you know, if you're, you know, comparing, contrasting, there are different transitions. And that's, you know, we all have a good sense of that. But what I see less of is a third kind, and that is more of a substantive transition. And if you go back, you've written your argument, you use your headings for your primary transitions, you have some generic transitions to move your work along. It's a good idea to think about where you can put in substantive transitions that really tie the piece together. I think the best legal writing does this kind of naturally. But when it's not natural, you kind of have to be more intentional about it. And so what you want to think about is, and if you think about a substantive transition, what does that mean? Well, we had an example about the Equal Protection Clause. If you were to say something like, you know, the 14th Amendment of the United States Constitution and Article 1, Section 7 of the Connecticut Constitution govern equal protection, or equal protection is governed by those 2 clauses. Your next sentence, a good substantive transition would be, both of those provisions have been interpreted as, right? We kind of take something from the old sentence and we transition to the new sentence by using that. My son actually just got a writing assignment back, though, where he tried to use kind of this or these provisions. It's usually like this or that or these, right? You take something from the old and you transition to the new. And the key is you have to actually refer to what you have to be more explicit what you're referring to. You just can't say, for example, if you were to say, at common law, duty is established when the defendant stands in a special relationship with the plaintiff. And you can't just say, this can exist between, well, you would say, this special relationship can exist, right? You always have to refer to that. But those, you're probably pretty familiar with those type of transitions. But I think when you look back at your work and you see, you know, when you start editing for transitions, to look at from paragraph to paragraph or from section to section. If you look at every paragraph, usually paragraph, sometimes within a paragraph, every block of writing, if you can think about how can I specifically and explicitly tie these 2 ideas together. And the most typical example is like you might spend an entire paragraph describing the law of, the law of a case, the law of the Smith case. Well, your next paragraph, a dovetail, a way of transitioning might be, under the rule announced in Smith, comma, and then go on. It's almost every paragraph or every section, and it's kind of on a small level and a big level, the smoothest writing's transition, even between sections. So let's say you have an employment case where you had a section about actual termination, and then you're going to move on to constructive termination, constructive discharge. a good transition might be, unlike an actual termination, comma, a constructive discharge requires X, Y, or Z. It's ideas being tied together. Take something old from whatever component, whether it be at the sentence or paragraph level or between sections, and always tie it. And that's best done oftentimes when you go back, especially if multiple people are writing a document to tie everything together. So late in the day, those 4 things, I think, will help you at least move your editing skills forward a bit. Thanks.
Just quickly, some points that without referencing a lot of very good points. One of the comments that were made always is about the length of the brief and for you to get focused, make it short sentences, short paragraphs. What we tend to do is, many judges, we learn to speed read whether we wanted to or not. We don't sit and agonize over your briefs word for word, paragraph for paragraph. We have to read them quickly. To give you an example, I left Omaha yesterday late afternoon and brought 6 cases with me. So last evening, besides dinner, I got through the briefs in 2 cases. This morning I got through 3, and on my way home I'll read the 6th. That's how much time that I can afford to give to your cases. And now, obviously, I was taking notes, separate piece of paper. I'm writing notes about each one of the cases and the arguments of both sides. Shifting to another question was asked, who do you write for? Do you write for the judges or the law clerk? And I can tell you the answer to that is both. You have to write for both. And the balancing act that you have is how much you're writing for one and how much for the other. But just remember one thing. Who's the decision maker? So your emphasis should be in writing for the judge. I compliment Sylvia Walbolt's discussion on outlining. It's very good. Judges could also learn from that of outlining opinions before they're written. Brian Finley's discussion of the opening, I will tell you, and other people mentioned this, the summary in the brief and the opening part of an argument is critical. That's where you get my interest. And it's also where you lose my interest. Because if you have a compelling argument either on the facts or on the law or both, that's where you're going to get me really involved in it. And as I said, I don't have a lot of time to wait and find it in the middle of the brief. Brian, I want to also mention Brian O'Neill's comments about the narrative and the factual. It's very important to have a persuasive argument, only you're giving a factual story. But don't do the comments that he refers to as assertions, where you say the other side's a drunk or whatever. Let the court come to that conclusion. All you have to do is say they were inebriated, they had a blood alcohol test of 0.2 or whatever it is. And let us come to the conclusion. We feel much smarter when we come to the conclusion than if you pound it in to say and make those comments ahead of time. I would also want to emphasize what Brian O'Neill said, talking about illustrations. I think they can be very helpful. That's not a unanimous view among the judges on the courts, but I will give you a quick example. We had a case, it's hard to believe it's in federal court, but it came through the bankruptcy system of whether a particular piece of equipment was a fixture or not. And we read the briefs, and all 3 of the judges, and none of us had a clue what they were talking about. And one of the lawyers showed up at argument, and he had this huge picture blown up. There was a picture of the inside of this building where this piece of equipment was, and then a couple pictures about how it was attached. And we looked at the picture and went, well, of course it's a fixture. And reading it, we had no idea what it was. So there's just a lot that you can do with those within reason. I want to re-emphasize Bruce Rogow's comment about themes, the importance of summaries, which I mentioned, and just about everybody said, you know your court, which I mentioned at the beginning, know your audience. Whether it's writing or oral argument, know the people that you're going to be presenting the case in front of, and try to write ahead of time with the knowledge of the whole court, and then hopefully when you have oral argument, you can focus then on the judges you actually have in your panel. Professor Colby's short paragraphs, short sentences, I wrote that down because that's important, it keeps it short. I would add two other comments, and these may seem minor, but one of them goes back to Judge Richard Arnold's comment about reason is more important than authority. And the reason for the law, the reason for why the court has made certain decisions, and often the court doesn't say it, and often it's not in the statute and the legislative history. You have to reason for that and come up with your own reasons. Why would this be the law? Why would this be the case law precedent? And I'll give you an example, a case that I briefed and argued in Nebraska, in the Nebraska Supreme Court, and we were relying on a similar statute in South Dakota. And we couldn't find anywhere why this statute was presented and why it would be there. So I wrote a paragraph of the reason for the statute. This is going to get into my second point, and just made a positive statement. This is the reason for the statute, no doubt. The Nebraska Supreme Court picked that up, found in our favor, and wrote the reason for the statute word for word that we had in the brief. And I made it up in whole cloth. We didn't have any idea what the reason was. But it was persuasive. It was not arguing. We were coming up with a fair reason why a legislature would pass this law. My second point is, this may seem minor, but I'll tell you it affects me, and that is to make positive statements of your position. As soon as you say, we believe, we think, we contend, it is our position that, right away I'm thinking, well, they're not very confident in it. And the worst thing you could say, let's say it's a criminal case, is the defendant's position is. Because that's telling me, well, your client wants you to argue that, but you really don't believe in it. What you should do is make a positive statement. The sentence is unreasonable. Not, we believe the sentence is unreasonable, or the defendant's contention is the sentence is unreasonable. So use positive statements because I tell you, its human reaction to reading that is going to be contrary to what you want. I think that's more enough. I could go on highlighting what the wonderful speakers you've heard here and the great points that they've given to you. And I hope you commit these to memory and use them in your practice. I would like to end on two points. One is I'd like to paraphrase a saying by one of the Missourians here, Mark Twain, and apply it to what we've done here today. Always write persuasively, as you've learned today. This will gratify some judges and astonish the rest. Then I would like to end with one other quotation from a great judge I had an opportunity to practice with. He's now a senior judge, United States District Judge in Lincoln, Nebraska, Warren Erbaum. And he said this, he got up to receive an award from the Inns of Court, and his acceptance speech was this. And I'd say this to end on a note of professionalism. Honor the law. Respect the law. But never worship the law. Because the law is the lowest common denominator. And you can do better than that. So thank you. And thanks to the American College.